In this video, I'm going to discuss criminal trials in the District and Supreme Courts of Queensland. If you plead not guilty to some or all offences on the indictment, then your matter will go to trial. Trials in the District and Supreme Courts are heard before a judge and jury. There are situations where there can be a judge-only trial, but these are rare. Judges handle all of the issues of law during the trial, for example, admissibility of evidence, instructing the jury about legal issues. Juries determine all of the factual issues. The jury will be present during the trial for the period when the evidence is produced to the court. At the end of the evidence, the jury decide if an accused is guilty beyond reasonable doubt of the offence on the indictment or not guilty. So at the start of a criminal trial and during the trial, the defendant sits in the dock, which is generally at the back of the courtroom. Generally, trials in the District Court and Supreme Court are conducted by barristers. If you have one, they will sit at the left of the bar table along with an instructing solicitor. The Crown Prosecutor from the Director of Public Prosecutions stands to the right of the bar table. First starts off with an arraignment. When a person's charged on an indictment of the criminal offence, they will need to enter their plea to the offence. That is, whether or not they are pleading guilty or not guilty of the offence. And this process of entering a plea is called the arraignment. This process is usually performed in front of the jury pool of persons, 12 of whom are chosen as members of the jury for the defendant's trial. The defendant stands and the judge's associate asks them how they want to plead, that is, guilty or not guilty, to each offence on the indictment. The process is as follows. The judge's associate speaks. They will say the defendant's name is charged on a particular day at a particular place with a certain offence. They will ask how they plead, guilty or not guilty. The usual response by the defendant is not guilty. The judge's associate then turns to the judge, tells him or her the plea to the count on the indictment. For example, they'll say not guilty, Your Honour. If there's more than one count on the indictment, the judge's associate goes through the same process for each count on the indictment, one by one. The jury is then impanelled, that means selected. So once the defendant has been arraigned, 12 persons from the jury pool will be selected as the jury for the trial. Prior to the trial starting, the defence lawyer gets a jury list from the court registry. Each potential juror is given a number on the jury list. The jury list details for each potential member of the jury, such as their allocated number, their name, their occupation, if they have one or if it's been provided, the suburb where they live. During the selection of the jury, the defence and prosecution can each say they do not want a person on the jury. If either the defence or prosecution say they do not want a particular person on the jury, this is called a preemptory challenge. The defence and prosecution each are allowed up to 8 preemptory challenges. This means the defence and prosecution can each only challenge 8 potential jurors. When the defence challenge a juror, the barrister for the defendant usually says challenge, but the prosecutor will say stand by. The jury selection process is as follows. 1. The judge directs the associate to impanel the jury and then to inform the defendant the right to challenge. The judge's associate will say something like the following. The defendant's name. These representatives of the community whom you will now hear called may become the jurors who are to decide between the prosecution and you on your trial. If you wish to challenge them, or any of them, you or your representative must do so before the bailiff begins to recite the words of the oath or affirmation. 2. The associate will say to the pool of potential jurors, members of the jury, please answer to your names. 3. The judge's associate places cards with the number of each juror into a barrel. The associate spins the barrel and takes out a card. The associate will read out the number and the name of the potential juror. 4. The potential juror will walk towards where the bailiff is standing to be sworn in as a juror. The bailiff will ask the juror if they wish to take an oath or an affirmation. The bailiff will then start to take the oath or affirmation for the potential juror. Up until the point of when the oath or affirmation has been administered, the potential juror can be challenged either by the defence or the prosecution. In some situations, a potential juror may be challenged before they've even made it to the bailiff. 5. If a juror is challenged, the judge's associate will place the card with the number of the potential juror who was challenged into a pile. If a potential juror is sworn in, the associate makes a note of this in their notebook and hands the card with the number of the juror on it to the judge. This process of selecting a jury continues until 12 persons are impanelled as the jury. The judge will then provide remarks to the jury. So after the jury is selected and before the persons who were not selected as members of the jury leave, the judge tells the jury your name as the defendant, the offences you are charged with. The judge then asks the Crown Prosecutor to read out the names of the persons who will be called as witnesses in your trial. The reason for this is so any jurors can see if they recognise any of the names of the witnesses. The Crown Prosecutor reads out the names of each witness and they may provide details about where they live or work. The judge will then tell the jury how it's important they be impartial. The judge will ask the jurors if any of them feel they cannot be impartial or if there's anything about the trial they believe would prevent them from performing their role as a juror. If any jurors say they have an issue with the judge will speak to them and decide if they should be discharged from serving on the jury. The associate will then speak to the jury. The associate will read out the names of each juror and ask them to individually answer to their names. The associate reads out the charge or charges on the indictment to the jury. The associate will tell the jury the defendant says they are not guilty to the charge. It is their duty to say whether the defendant is guilty or not guilty of the charge. It is their duty to pay attention to the evidence, and they are to choose a member of the jury to be their speaker. Then there's a proclamation to witnesses. The judge will ask the bailiff to make a proclamation to witnesses. This means the bailiff will say out loud that all persons who are witnesses in the trial should leave the courtroom until they are called upon to give evidence. The bailiff will then be sworn in. The bailiff will then be sworn in, and this means they take an oath on the Bible or an affirmation to swear they will not communicate with the jury or allow anyone else to communicate with the jury, unless this is obviously authorised by the court or by the law. The judge will then provide opening remarks to the jury. So the judge will generally talk to the jury about various things, including the following: the offence on the indictment or offences, their role as the jury during the trial, the prohibition against making their own inquiries about the defendant. After the judge has given opening remarks, the prosecution will provide an opening address to the jury. So the Crown Prosecutor will tell the jury what the trial is about and the evidence the Crown expects each of their witnesses will give. The prosecution presents their case after they have given the opening remarks. So they will call each of their witnesses one by one to give evidence. When a witness is called to give evidence, they sit in the witness box. The witness will not have the benefit of their statement with them. The witness must give evidence based on what they can remember from their memory. The bailiff of the court swears in the witness. The bailiff will ask the witness if they wish to take an oath on the Bible or an affirmation. And this is to confirm the witness will tell the truth during the trial. After the witness has taken an oath or affirmation, the Crown Prosecutor will ask the witness questions. This is known as examination in chief. The questions asked by the Crown Prosecutor cannot generally be leading questions. And leading questions are questions that in themselves suggest the answer to the question. So for example, if I said to you, the car that went through the red light was blue, wasn't it? I'm suggesting to you the car was blue, rather than allowing you to tell me what the colour of the car was. When the prosecutor or the Crown Prosecutor has finished asking witness questions, the defence then can ask the witness questions. And this is known as cross-examination of the witness. During cross-examination, the defence can ask a witness leading questions. However, the defence cannot ask a witness anything they want. The questions must be relevant to the issues to be determined at the trial. That is, they must have some relevance to the trial. When the defence has finished asking witness questions, the prosecution has an opportunity to ask the witness questions. You'll hear the judge ask the prosecution if they want to re-examine the witness. After the Crown Prosecutor has called each of their witnesses to give evidence, the defence can then call witnesses if they want. Witnesses called by the defence may be the defendant or some other person who helps the defendant. The defendant will not always call witnesses to give evidence. It's a case-by-case matter as to whether or not witnesses are called for the defendant. Once the case is closed, there's closing addresses. So at the close of the prosecution case and the defence case, each side has an opportunity to give the jury a closing address. The order in which closing addresses takes place depends on if the defendant presented any evidence or gave evidence. If the defendant did not give evidence or present any evidence, the prosecution gives their closing address first. There is some school of thought that it's best to close last, because it's the last thing the jury will hear before they listen to the closing remarks of the judge and directions. The judge then sums up to the jury. So at the end of the closing addresses, the judge will sum up the evidence to the jury and give them directions about any legal issues that arise at the trial. So, for example, if self-defence is raised on the evidence or provocation, then the judge will discuss this. The jury then retire. So after the judge has summed up to the jury retires to deliberate. They'll go out of the courtroom to decide if they'll return a guilty or not guilty verdict. If the jury returns a guilty verdict, you'll be sentenced. If the jury return a not guilty verdict, the defendant is discharged and free to leave. If the jury can't decide if the defendant is guilty or not guilty, the judge will discharge the jury. This means the jury are not made to reach a verdict and they're let go. What this means for a defendant is that they'll be likely to stand trial at a different time in the future. The matter will be mentioned in court on another date and a new trial date will be set. This is unless, obviously, the prosecution discontinues the charge, which in most cases is unlikely.